where JD is, taking a day off. I
He's
guess
in
Bryant lets him do
Mexico.
that. I don't let
Yeah,
Stuart do that.
I don't have a choice. He'd be here working if I had my choice.
Yeah, Stuart doesn't do that for us. But I'll go over intros quick. I'm going to let Megan introduce herself after. But you got Bryant with Control Core, CEO. If you have any questions on job costing or anything accounting, he's kind of boring to talk to, but he's pretty smart. I'm just kidding. Both. He's fun to talk to and smart. You have Peter and Amy Hook with National Lien Service. I've personally worked with them to get some people paid. If you ever have any trouble and you want somebody to help you before you get the attorney involved, they are good leverage. And I am Josh Lupker, the construction CFO. I don't really know what I know. I just kind of do stuff as I go. And then you have Megan Shapiro, who is our special guest today. And the reason I wanted to have Megan today is because all of us are going to be at Converge Construction Summit in
Yay!
Chicago in about 6 weeks. Tickets are still available for about 2 more weeks, but I'm going to let Megan introduce herself. And then we're going to dive into more contract questions and really get gritty about the questions that people are afraid to ask their attorney or it's too late. So, Megan, why don't you go ahead and just tell us a little bit about you, what you do, and who you are.
So I am Megan Shapiro. I'm a full-time construction attorney. I have been doing this for, oh gosh, I don't know, like 17 years or so at this point, primarily on the litigation side. So the bulk of my practice and experience has been when the claims and issues and disputes get so far along that lawyers actually get involved. So I kind of realized a couple of years ago that I was seeing a lot of common trends, a lot of common themes. And I thought to myself, boy, there's a lot of ways that we could be preventing these lawsuits from being filed if we were a little bit more proactive on the front end when we're looking at the contracts. So I've now sort of incorporated teaching construction leaders how to review, redline, and negotiate their contracts the same way I do it. They do it like a lawyer methodology, so that way you don't necessarily need your lawyer every time a new contract comes across your desk. And it sort of helps prevent some of those claims, because the thing that sort of sets me apart from other construction or contract attorneys is that I've always been on the litigation side. So my whole process and method is informed by seeing the worst of how it can go wrong, and living that courtroom battle. In addition to that, I'm also an accidental construction conference founder. So that's Converge, super excited about that. And the last thing I will say about my introduction is I too have relied on the Hooks for assisting some of my clients with lien stuff. So it's not just before the lawyer gets involved. Sometimes the lawyer gets them involved as well. So excellent resource they are.
Yeah.
Oh, thank you.
Thank you for joining us today. And I'm going to just go straight into it and really go for the jugular, if that's okay. And I'm going to target this one first to Amy and Peter, because they see it all the time. But can you kind of explain to us what you see with what I'm going to call boiling the frog? How liens get started, or how you get brought in too late, and what the risk is with, like, at what point does inaction hurt you?
I think inaction hurts you from day one, honestly, which will kind of frame up looking at the contract early on. But usually when we're involved is going to be, and we have a good mix. We have a good source of clients, and this is kind of how we train our clients in discussing and consulting with them from the get-go, is that proactivity. If you do something by a certain date, then you're going to keep yourself ahead of the runway. What happens is a lot of, Peter's got an aviation background, so we do a little bit of aviation reference, but when the runway is behind you, there's nothing you can do. There's absolutely nothing, and you can't get that back. Statutes, and Megan can attest, are solid. There's not an if-then. There's no gray area when it comes to statutes. Well, I guess there are actually a lot of gray area when it comes to statutes.
No, when it comes to lien statutes, though.
But the lien statutes, when it comes to time frames, are pretty clean. At least time frames. They may not be all really clean when it comes to what you need to do, but when you need to do it, no, absolutely, we're going to enforce. I think just understanding what state you're working in, whether it's a proactive or a reactive state, whether you have to proactively do something at the onset of the project in order to secure your lien right, and then understanding at the end of the project when you need to do things. It's really important. Engaging either a lien specialist or especially your construction attorney in those places, in those conversations early on, especially if it's a state that you're new to, because a lot of contractors are now branching out into their neighboring states. It's really going to help. But what we see is a lot of money left on the table, a lot of money that has to be walked away from.
Yeah.
And then when they come to you too late, it will put a document preparer in a position to draft quickly, which we don't like to do. We want to have enough time for our client's counsel to review the lien, which we always advise. If they don't, then, but to also look for any changes. It also gives us time to fight with recorders' offices throughout the country.
And to pick up on the aviation piece, so in aviation, they teach you that there are basically two kinds of errors: errors of omission and errors of commission. So you can either do something you were supposed to, not do something you were supposed to do, or do something you weren't supposed to do, which is why pilots use checklists so that they don't do either one of those things. And what Amy's talking about is, and Megan also, is the same thing. It's like everyone in construction got the Ted Lasso goldfish touch, and they just forgot. They always forget the last project that they got screwed on. So have a checklist and follow it.
Yeah. So the next thing I wanted to stay on the same topic, but Bryant, I mean, when we onboard clients, just to put this in perspective, how many pay apps have you seen that we've migrated over, and then within 2 or 3 months, it's like, hey, these ones are, a year or two old. Are you ever going to get paid? And they're like, no, we're just going to have to write that one off.
Yeah, no, that's what I was thinking of, is you guys were talking about it. I typically, when Control Core comes in and we start the migration process, we have basically an AR like come to Jesus. Like, is this really, are we, what's going on with these ones? And some of them are a lot worse than others. And depending on what state they're in, my first sets of questions are, have we done the pre-lien work? Like, is there any chance that we're going to collect on these? Can we even, do we even have rights to go and find these things? So it happens all the time. I think that a lot of people just think, nope, it's not happening to me. I've got my processes dialed in. But for us, like, it's pretty much a part of our standard process, is like, let's have this AR come to Jesus moment.
Yeah.
And into that, the number of times that, especially the last 2 years or so, that we've heard, I've never had to do this before. I've been in business for 25 years, 30 years. I haven't had to do a lien. I've never had to look at this. It happens more often than you'd hope. And there's no one that is immune from this. Not a single person, because unless you are the bank cutting checks, you have no control over when you're going to get your money.
Yeah, Megan, how do you coach people when it comes to like that psychology of, it's easier, I'll just wait. Like, they said it'll be Friday, and I don't want to get my legal involved because then all this stuff, but then pretty soon it turns into 3 weeks or a month. And by then you could have been paid if you brought in legal and pounded them when it mattered, right? It always takes that 30 days.
Yeah, I think like my sort of, I don't know if you want to call it like DEFCON 1, right? Like, if you're going to, in terms of escalating the amount of the conflict and how severe your response is, my go-to out of the gate, especially if the project is still ongoing, if you have overall otherwise a pretty good relationship with the GC, or if you are the GC with the owner, whoever is delaying the pay app, I will oftentimes sort of ghostwrite the correspondence around payment being late. So, and when I say ghostwrite, I mean, I'm not just literally writing it like the same type of correspondence that would come from me as your lawyer. I'm writing it like it's coming from you, so that you're still trying to preserve that relationship. All of my contract stuff is predicated on the idea that we need to do our best to preserve the relationship to the extent possible. Like, it's relationship forward, right? And so in that vein, I want to sort of start there, because it shouldn't be this way, and I think you definitely, Josh, would agree with this. It shouldn't be this way, but as soon as a lawyer is officially involved, everything goes nuclear, because nobody wants to be negotiating with the lawyer by themselves. And so you bring in your lawyer, they bring in their lawyer, and now the lawyers have to. We always feel compelled to prove our value and our worth to our clients, and sometimes our clients want to see us fight, because if they're paying me, they want to see the fight. They're more interested in the method of delivery than the outcome. And the other attorney is under that same pressure. And so where we otherwise might be able to have a collaborative conversation and reach a resolution that actually is mutually beneficial to everybody, that does preserve the relationship and allows the project to proceed on time and on budget, we've now potentially put ourselves in a situation where we're fighting just for the sake of fighting, so that everybody's clients are impressed. And that doesn't benefit anybody. And it actually costs the clients more money anyway, because now you got to pay us to fight instead of paying us to just help guide you through the process. And so it's always circumstantial, of course, but that is usually my first, at least, attempt at getting involved in helping resolve a slow pay or a payment delay. To prove our value and our worth to our clients.
Yes, sorry. I pulled up LinkedIn because I want to look at the comments, and you make a really good point. It just, everybody wants to go nuclear, but then also everything slows down. It's like, oh, my lawyer hasn't responded for a week. I have to bother them, and it's playing a game of telephone. Nobody and the problem is you need to speed things up at that point. It's like you only have so many days, and your lien timer is gone, and you lose your right.
And I think another thing to keep in mind, to piggyback off of what Megan had said also, is we've seen one of the things that we'll talk with clients, and even in our approach and how we're trying to support our clients, is how bad do you want to maintain the relationship with your customer? That is the number one question. And when the answer is no, it's like, okay, get your lawyer involved, get them involved now. Just get it out of the way, be done with it. You're never going to work with this individual ever again. You want to maintain the relationship? Well, then it's going to depend on where tier you are, right? If you're the GC that wants to maintain the relationship with the owner, we see it a lot. Subcontractors will be asked to lien it. Please lien it. Where they'll ask the favor. A lot of general contractors will ask their subs and suppliers, lien it, because that's going to get money going, and they still look like the bad. Oh, these bad subs. These bad suppliers.
These
whatever.
Dumb.
At the end of the day, nobody wants to be the bad guy. But then when it comes down to it, if the client says no, and I have seen in some cases where, at least with a lot of the clients that we work with in certain geographical areas where a lot of the attorneys know each other, a lot of them network together, a lot of them know kind of what a lot of these general contractors or owners are dealing with. If your lawyer's involved and their lawyer's involved, 9 times out of 10 you're going to get this resolved a lot faster than if you just sit here and continue to send out demand letters. But you should always, to Megan's point, send out your own first. Send out a demand letter. If your attorney is willing to ghostwrite for you, take it, and then try to make the attempt. But another thing that we see a big problem with, and Megan, let me know what you see, because I'm sure this is when you get it. You get the when it hits the fan, is when people sit on the mech lien. They'll have their mechanics lien. Mechanics liens will statutorily discharge over a certain amount of time in most states. And a lot of people will come to us 9 months later, and in Arizona, you have a 6-month shelf life. After that, you're gone. It statutorily discharges. 9 months, a year later, what can I do with this? Not nothing. A whole lot of nothing. You just spent a lot of money and caused a lot of heartache to do nothing with it. And guess who knew that? Your recipients knew that. They knew you weren't going to do anything. Did you send demand letters? Did you engage your attorney? What did you do? Well, I did nothing. I thought I liened it. A lien is not a guarantee to payment. A lien is a solid negotiating point for you to say, I will take this property from you. I will take the dirt from you if I can, and I'm going to have my attorney do it. But that takes time. All of that takes time. So not only know when you need to file your mechanics lien, but know when it's going to die off, when it's just going to expire, because they will expire.
And I just want to piggyback on that too real fast, because one of the things that always surprises me when I'm talking to a new client, so they haven't worked with me before, so they haven't yet had the opportunity to be educated on some of this stuff, is they will end up in a situation where they are not getting paid. It's been a long time. They didn't do what they needed to do to protect their lien rights for whatever reason, right? They didn't do the pre-lien the right way. They didn't do it on time, whatever it is. In their head, because sometimes they're not even right, but in their head, they don't have mechanics lien rights. And they then wrongfully assume that they then have no remedy, that they then have no ability and negotiation leverage. And that's just simply not true, right? Like, a mechanics lien is a great remedy that you have available to you if your upstream party fails to pay you, 100%. But it is not your only remedy. You can still actually send a demand letter just based on the contract terms themselves. Failure to pay pursuant to the payment provisions contained within that contract is a breach of contract, regardless of your lien rights. So what that looks like in practice, to put a little color on that, make it less abstract, when you come to me, one of the first questions I ask you is, do you still have mechanics liens rights? Did you do what you needed to do, right? I want to establish that out of the gate. If the answer is yes, or I think so, then my demand letter is actually twofold. My demand letter is, pay us, or we're going to record a mechanics lien and we're going to sue you for breach of contract. If your answer to me is, no, I don't think I do have my mechanics liens rights, or no, I know I don't, that's why I waited 10 months to call you, because I didn't know what else to do, because I thought I didn't have an option. I say to them, okay, now I'm still sending a demand letter. My demand letter is just going to either bluff about the mechanics lien, depending on the sophistication level of the other upstream party, because sometimes I bluff. Let them call me out on not having the rights. Yeah, that's my secret. But even still, I will include a demand for payment based on the breach of the contract. So I just think it's important while we're talking about lien rights to remind people that lien rights are an incredibly valuable tool, but it is not the only tool you have. So don't assume that you're shit out of luck just because you think you don't have lien rights anymore.
And to piggyback off of that, we're just gonna be piggybacking all day, Megan. These
That's
guys.
why we get along so well, Amy.
I love it. But even on top of that, look at your state licensing boards. Certain state licensing boards also have provisions for non-payment. Arizona is a good example. The Registrar of Contractors has a complaint for non-payment. We have found a lot of clients using that in tandem with their mechanics liens, and they'll go right through the state contracting boards. So it is something to look into, especially if you're contracted with another contractor. And I should say really quick, because I do get this question a lot, if I am a second tier sub, can I put in a complaint against the GC? No, you can only put in a complaint against who you are contracted with, 9 times out of 10. But look at your resources, engage with your legal counsel, engage with your team, your AR team, to say, look, what are our options? I've said it in the last one. I've said it again. It is like my mantra. I will have it tattooed on my forehead at some point. Old English font, like I said, is other than just document, which is like, that will be the first one. And I think the second one will be, before you get into a project, know how you're going to get out of it.
Yes.
Mm-hmm.
Yes. And if you don't have a construction attorney, get one.
Get one.
Please.
Have somebody on.
Not
somewhere.
a corporate attorney.
Yeah.
Not the person that drafted your wills and trusts.
What
Please.
is right? What is the old saying? And there's 3 levels of construction. There's pre-construction, construction, and lawsuit. I mean, get a construction attorney.
Yeah.
Yeah.
Megan,
Oh, sorry, Brian. Go ahead.
Oh, sorry. I just wanted to ask a question. So you go first, and then I'll ask you a question.
Well, I was just going to give one quick caveat to Peter's very solid recommendation to get a construction attorney. Get an actual knowledgeable construction attorney. Not all attorneys who claim to be quote unquote construction attorneys actually understand the nuances of the contract side of things. They may have only done, for example, insurance defense work related to construction defect litigation, for example. They may not necessarily understand the nuance of what Peter and Amy are specifically referencing. So don't just take them at their marketing face value of I'm a construction attorney. Ask some questions, do some due diligence, dig a little deeper. If you're unsure in any way, you can find me on LinkedIn, send me a DM. I'll at least give you an idea of what questions you should ask them to vet whether or not they are going to be a good fit for you, whether they're true construction attorneys or not.
And real estate attorneys are not going to be construction attorneys.
No.
Another thing,
totally separate fields.
Totally. And here's the other thing that I will say on attorneys, and then Brian, well, I'll go ahead and shut up so you can ask your question for Megan. But here's my last one. I'll probably have this one tattooed under my cheek. I think the cheekbone would be a good one for this one.
Tears?
Is there are Peter's? Oh, he's fine with it.
Yeah. Totally.
So just the big ones, all face. But another one too is the reason that there are disciplines in law, like there are disciplines in the medical field. You don't go to an ear, nose, and throat doctor for your hemorrhoids. So please don't go to someone that is not a verified construction attorney to do your construction bidding, to go out there, not bidding, obviously I'm using it differently, not obviously, but you really do need that. And I've had plenty of clients come to us saying, well, my corporate attorney is looking at it. Well, do me a favor and have your corporate attorney run it by their construction partner. If they don't have one, then I would highly advise. When I tell my clients, if I look at you dead serious, like I'm not breaking eye contact, and I said, please get a second opinion, please, then I'm telling you to do it, because I can't tell you. I'm not an attorney. I can't tell you, no, that is wrong. I legally can't do that, but I want to so bad.
Hey, Brian, before you ask your question, I just wanted to pop it back in there. Megan does have a checklist for different contract things, whether it's probably what questions to ask, checklist to make sure you do it right. So she'll put those in the comments. I'll put them on YouTube for those who find this later. Also, remember Converge. We're going to be there June 3rd through the 5th in Chicago. All of us meet us in person. It's a smaller event. It's not thousands of people. It's just literally a room full of people. You get to know every single person personally. And every single one of us will be there.
In fact, I was going to say the 4 of you, but your whole groups only
Yes.
started working together after meeting in person at Converge last
Yep.
year.
Correct.
Yes.
It was a wonderful event, and
It was.
the people there were wonderful. Everything that we experienced was amazing, and if you have a chance to go, I would highly recommend it.
Highly, highly recommend it.
And next year, this time, you'll probably be on a podcast with us for no reason other than you just like each other and like working.
There you go.
I just like talking to you.
You'll get mean tweets thrown at you.
It's
Yeah,
fine.
yeah, that's true. I'm not
Unless
doing
you're
that
Bryant,
today.
because apparently we don't let Bryant talk.
Yeah, I'm gonna let Brian go now. I'm sorry.
No,
guys. I just
no,
wanted to
no.
make
That's
sure I
okay.
threw that
You
out
don't let the accountant talk. Like, they belong in the cave, in the corner.
Yes.
Everything you said about making sure you find a construction attorney is also true for finding a construction accountant. Just because somebody's profile says that they do construction accounting doesn't necessarily.
We found them, haven't we, Brian?
we've
We found some people that they're like, oh yeah, I do job costing. That's
Yeah.
totally what I do. And then
I've had conversations with quote unquote business attorneys, right? And they'll say, well, yeah, I'm a construction attorney because construction's business. Construction is a business. And I'm like,
Oh,
okay, well,
my.
like the second half of what you said is true. Construction is a business. But if you don't know anything else about construction beyond the fact that it is a business, I feel very bad for your clients, because if you don't even know what an RFI is, because that doesn't exist in a lot of other businesses, if you don't know what the difference between a COR is and a CO, your clients are screwed. And like, I hear you, because I've literally had that and more than once I've had that conversation with business attorneys who are like, well, construction's business, so I got it.
Same holds true in the technical world, in developing. Same thing. If they don't have construction knowledge, everything is, oh, it's just a fillable PDF, no problem, we got this.
Yeah.
Yeah. No, it's not. No, it's not.
template.
But Megan, my
Yeah.
question was going back to the liens versus the lawsuit suing for breach of contract. At what point do you typically see, and like when you get involved, if they've already started down the path of the lien versus they've already started down the path of the lawsuit, like which one is harder or more difficult for you guys to untangle?
Good question.
Nothing is really all that challenging to untangle. And that's not me patting myself on the back, like, because I'm a genius. It's just because the laws in the court systems are designed with those sort of built-in checks in place so that nobody gets like a really bad hammer because of mistakes that may have been made, particularly early in the process. In California and in a lot of other, so I didn't mention it in the beginning, I don't think, but for those watching, I'm only licensed to practice law in California. I can only give legal advice in California, and only after you've hired me as an attorney. So I'm not giving #not legal advice.
#not legal advice.
Yeah, but in California, businesses, and now I'm going to go back to businesses of all kinds, but businesses of all kinds are not allowed to represent themselves in court. You have to hire an attorney. Unlike an individual, as an individual, you can go in what's called pro per. You don't have to hire a lawyer. You can just avail yourself of the court process. But businesses are not allowed to do that. You must hire an attorney to represent you. I say that because, to your question, Bryant, it's unlikely that I'm going to get involved at a point where a lawsuit has already happened, where they haven't had, I love it, thanks Josh, where they haven't had a lawyer, like they can't file the lawsuit themselves. So an attorney must have filed the lawsuit. Now, again, not all attorneys actually know what they're doing, but there are processes that will allow me to clean that up, to fix it if it's done in a way that maybe missed some things or misstated some things. There are processes that will sort of allow me to clean that up. To Amy's point at the very beginning of our hour together, one of the only things that I really can't undo is if you've completely blown your mechanics liens deadlines, because they are so strictly enforced that there's not much I can. I mean, I might try to bluff, right? But if they call my bluff, that's one thing that I really can't undo. Your ability to avail yourself of a mechanics lien remedy, but that again is unrelated from your breach of contract remedy. So I can still pursue the exact same amount of money that way. So there's very little that I can't sort of unfuck.
There you go.
Well, and also to that, it doesn't mean that there aren't statute of limitations on filing suit on breach of contract.
Yeah.
Correct. It's just much longer. It's a lot longer. You've got more time to sort of hem and haw and sit around debating whether you want to go down that path. You've got more time. But yeah, there is an outer limit.
There is, and I think that the largest misconception is that the mechanics lien is the end of the story. The mechanics lien is not the end of the story. As a matter of fact, it is the end of your first chapter. Your first chapter is securing, waiving, enforcing. The second chapter is your lis pendens. That's going to be your foreclosure suit. That requires things like a title search, which can take up to 4 weeks to get a proper title search done. That has to be purchased, has to be researched. Your attorney will have to go seek that out. I have had I used to work with an attorney who he's still around. He's just in house. But that he would tell his client he had to do a lis pendens in 2 days. And it was just, the dude it stressed him out to no ends, because then you can't guarantee it. I can't say that this is going to be completely accurate because you didn't give me the time to do the proper research. So we're going to wing it, and we're going to pray that we don't have to amend this or have it challenged and thrown out. There's, and by the way, Megan, love the bluffing. We call it bluffing with confidence over here. Bluff with confidence, bluff with your whole damn chest. Because if you're not, just forget it. Lay down, don't spend the money on it. But if you're going to bluff with confidence.
Also known as mad mugging.
Yeah. Mad
Can
mugging.
I just jump in real quick about that? Because I just realized ethically I might be getting myself in trouble. So let me give a caveat. When I talk about bluffing on whether or not we've blown our deadline for mechanics liens, I never do that in a lawsuit. That is unethical. I could be disbarred for that. When I'm bluffing, I'm purely bluffing as a negotiation strategy in letters and demand letters and ghostwriting, in the sort of informal outside of court process. I never bluff in a court filing or pleading. I would get disbarred for that. I just want to be real clear about that, because I know some of my opposing counsel follow me on LinkedIn and kind of watch what I say and do. So I'm just being real clear. I've never bluffed in a court filing. I never will bluff in a court filing.
We never bluff in it. And as long as it's not recorded with the county, right, we don't bluff in anything that's not recorded. If it's a recorded document, that's a different conversation altogether. Right. But if it's before that, and we can kind of encourage gently. Mm-hmm.
But all that could be avoided if you actually follow your time frames and have a checklist.
Yeah.
If you're a normal pilot like Peter and other people. So this is a great segue then, because I want to talk about the escalation ladder layer.
That's what I wanted to hear about, Josh.
When should everybody be brought in? Because in my mind, being a CFO, I see all the things, I start to notice, and obviously you want an attorney to help you negotiate your contract up front from a legal standpoint. Once you've done one with a GC, it's pretty simple. You just use the same template and then add your scope. But when we're talking about recording a mechanics lien and things like that, pay when paid, it's very fuzzy, right? But the way I found it is when you read the prime contract, it normally says 30 days, and then they have 10 days to flip it to you. So in my mind, if it's 40 days after the last day of the month that the pay app was due, that's lien worthy to start the process and at least have the ammo in your pouch.
So I want to take this one first, because I want to take the opportunity to really, really praise Peter and Amy and everyone else in their industry, right? Because even as the lawyer, I can do the lien stuff, right? But I'm going to automatically be more expensive because I have to charge you my lawyer hourly rate, and I don't need to use my law degree to do that part. But also because literally, there is no downside to actually having a knowledgeable professional get involved to make sure that it is done right, because the stakes are so high. And Amy and Peter know I've sent clients to them. Again, I can do it, but they're cheaper than me. And so I've sent my own clients to them and said, have them do it, and have them do it for all of your projects going forward. Sure, 90% of that work, especially pre-lien work, will hopefully be completely pointless. We never need to actually fall back on it.
But
if we do, wouldn't you rather know that it's been done right? So that way, when I do have to come in to actually foreclose on that lien, we remove the entire question and debate about timeliness and whether it was properly done. Because in California, you also have to make sure that the formatting is proper. You have very little room for error on the actual amount that you claim you're owed in the mechanics lien, whether you are allowed to include interest or not. It's nuanced, right? And there are experts like Amy and Peter who do this for you. And that is the best money that you will ever spend. Because again, very little I can't unfuck, but it's going to cost you money for me to do it. Why not spend less than that upfront with Peter and Amy and have them make sure that you're covered. So when I come in later, you're paying me less to just simply foreclose. Okay, now I'll stop. Sorry.
Yeah, no. How much is it to put a lawyer on retainer on average? Just
You know,
so
that is
people know.
so region. That's so dictated by region, right? Like I'm sure in Arkansas that number is way less than it is here in California. So I hesitate to really give an actual number, especially because I personally have various models that I offer to my construction clients because I am such a proponent of being proactive, and I know how many of my, especially my small trade clients, like
They're gonna
every
get
penny counts,
screwed.
right?
I
Every
guess-
penny counts. And
yes.
so I know that, but I want them to be proactive. And so I know that oftentimes they're sitting there looking at a contract, or they got an email from the GC, and they would say, like, in an ideal world where money was no object, they would want to call me and they would want to run it by me. But they also know that that's going to show up as a 0.3 on their bill. And they make the gamble, and they're like, you know what? I'm not going to involve Megan because I want to save the 0.3. And then now, 2 years from now, it's a $2 million lawsuit, and they should have just they should have paid me the 0.3. So because I've seen that so much, I have models that I will offer to my construction clients where it's sort of a flat monthly rate for simple advice and counsel. It excludes litigation because that's harder to control and anticipate the overall cost of. But for pure advice and counsel, you can enter into a flat monthly rate with me. You pay it to me every single month, no matter how much you use me. And the clients that have done that absolutely love it because of that reason. Not only do they feel comfortable picking up the phone and calling me for every single tiny little question, which I don't say that in a judgy way, I want that, but also they can then tell their C-suite or their PMs or their supers in the field, call Megan, it's not going to cost us anything. Pick up the phone and call her, because let's get the lawyer involved out of the gate on the front end proactively to avoid it being a $10 million problem in a worst case scenario down the line.
Yeah.
Yes.
And I think the part that people don't understand when you're talking about these small businesses, Megan, and you probably don't know this because, you know, you're on the lawyer side and the lien side. Peter and Amy might not know this, but like Brian and I see that these people literally, their businesses, when they're under 10 million, they have their house on the line. They have their whole family depends on this. So one delayed payment for 60 days, 90 days, like it can literally bankrupt a company, or not just a company, but an individual. They lose every possession that they have, and they don't have a place to live.
Yep, we've seen it.
Are you kidding? It's the email I sent off before this call.
Yeah.
I'm not joking. It's the email I literally sent off before this call. Our client has a personal guarantee on this project. $600,000 is what she's owed. Yeah, and we found out that well, the problem, no, she's got time. She's okay. It doesn't mean there's not a problem, because her license is suspended in Arizona. It was suspended about 30 days ago, and so now she's got to check with counsel to make sure that when the work was performed, that they're okay, because I think they're actually going to be okay on this. But again, that's something that their counsel has to say yes. But you know why? Because at the end of the day, I'm not going to defend you in court. Megan's going to defend you in court. That's the person who makes the decision. That's the person who should be assessing your risk. That's the person who should say, nah, dude, you're pretty effed on this one. You may have to look at other remedies. We're going to have to go about this a different way. But yeah, personal guarantees, I've seen it. I've got another one I talked to yesterday, Josh. And
they all have to do it.
They all have to do it. And that was they're owed $2,000, which she said, and she's so sweet. I love her. That's a lot for us. Yeah. Well, okay, well, let's go get it.
Yeah.
Let's go knock on doors and break some kneecaps. What we got to do? I got an Italian here. Let's do it.
It works.
It works.
I got an Italian. That's messed up.
And on that, not the Italian note, but in general. So acknowledge that collections is a risk that you have to price into your bids.
Yes.
This is going to happen literally on some project somewhere. So what would you do? You'd budget, how much it's going to cost to defend a bad project or lose a bad project, and you collect it on all the good projects so that you don't lose it at the back end. Again, a process. Have a process and follow it.
The way that I've seen it, I have a little bit different perspective than everybody else coming from project management. I've seen 10% of projects require a legal notice, and 10% of those projects actually have a lawyer involved, possible litigation. So we're talking to 1% of projects. But you don't know, that could be this one, that could be in 10 from now. And if you don't do the lien notices and you don't do your part now, that 10% goes up, right? Because you're not doing what you need to do. people don't want to go to litigation, but like the point I was trying to bring up, Megan, is I mean it's like 50 grand, even in Arkansas, to put somebody on retainer. And when we're talking about, 30 grand, that's a lot of money. That I mean for small contract for anybody really, it doesn't matter who you are. You're not gonna say yeah, just write it off. But it's either you put in the lien notice for I don't know, Amy. I'll let you talk about pricing on that. But like it's less than $1,000. So you do all this stuff, and at least you're protected. Or you pay 50 grand to try to get 30 grand, and you're gonna just decide you're gonna eat it and figure it out next time. So
by the way, I just want to say I deal with these as I'm the second call when people run into this situation, right? We call it cusp amounts, right? So first question I always ask is, do you sell mechanic lien rights? The second question I always ask is, how much are we talking about? Like, what's at stake, right?
Exactly.
Because
Is it worth it?
bad lawyers, construction lawyers, business lawyers, it doesn't matter. Bad lawyers won't care. Bad lawyers will only look at how good and how strong is our legal position with disregard to how much it's going to cost to collect that amount of money. And so I have that uncomfortable conversation a lot where I say, you're in the $30,000 to $50,000 range. If you don't have mechanics liens rights and our only option is to file a lawsuit for breach of contract, you're probably going to spend more than that to get it back. And I know that like me telling you that might be you looking at whether you can continue to stay in business or not, but it's worse if you go out of business because you're paying me my legal bill. And I never want to have to wake up in the morning and look myself in the mirror and know that I was actually the reason that one of my clients went out of business, because I allowed them to pursue a claim that I knew was going to cost them more in attorney fees than they were ever going to get back, even on their best day in court. And 97% of these claims still don't resolve in court. It's always it resolves as a compromise. So they're not going to get 100% of what they're entitled to. And so, but there are bad lawyers who will allow you to do that. So when we go back to the conversation earlier about what you should be looking for to make sure that you have a knowledgeable construction attorney, make sure you have an ethical one as well.
Yeah.
Agreed. And we'll see it out. It's same. The cuspers. I know exactly what you're talking about. I'll tell my clients, if you had another zero on there, or maybe another 2 zeros on there. Josh, you and I have had this conversation with a client before. If I would say, yeah, engage legal right now all day, because it's good. That's worth it. But when you are talking about a 30, 40, even a $50,000 claim, and you're just like, I'm going to engage legal, and you don't have in-house, or you don't have someone on retainer, you don't have someone that's doing the demand like Megan has with this basically a subscription access point for her. But before you get to litigation, it's not worth it. Because you're right, Josh, what your number you threw out is even what we see in Arizona. That's what we see for a foreclosure suit. Because guess what? Just because you have an attorney on retainer does not mean that you don't have to then put another chunk down for just suit, for filing suit. And that is not a little. It's a lot.
Yeah.
When you're talking
that's
50
one.
grand. Go ahead.
Yeah, that's one of the big advantages of following the mechanics lien path. It's a lot less expensive on the front end and is actually pretty powerful. So,
and a lot of statutes will write in, depending on the state, a lot of statutes have written in that you can get your attorney's fees recouped through the lien if should you go to litigation. It is something that a judge will have to say, yes, this is what we're going to do, but you at least have recourse.
so don't skip the step.
Don't skip the step.
Yeah, just
You can put that on your forehead.
Don't skip the step.
Yeah, there's Peter's tattoo.
Forehead tattoo.
Something we've been toying around with in this partnership of working with Bryant and with National Lien Service is at the last week of the month, we always do cash flow forecasting. And I look at when are these payments coming in? And if I know, like, hey, this one's coming in the middle of May, for example, and it was due, in April. Hey, you tell me, is it go or no go? Because I will get them involved. I will get them all the information. We'll have it done by Friday. If you want this liened, if you want the demand letter, if you want all the stuff sent out. And it's just like a regular good business practice. And what clients love about that aspect is like, they're not the bad guy. It's just like the GC saying like, well, I don't know, the subs are just leaning the project. Like, well, hey, I have this National Lien Service on retainer, and whenever I'm not paid within contract terms, they just send it out. Like, to solve that, you could just pay us, A. B, like, I'm not gonna, like, I'm sorry, let me look into it, but it starts the discussion faster and it gets a result faster.
It does, and I'll say something. I think I might have said it on a different one of our different sessions. Couple of things. So to secure the lien right, for in most states, the base price is $35 entire dollars. $35 entire dollars to secure a lien right that's worth multitudes more than that. But when you're doing that, and clients that are smaller size clients are like, God, that's, you know, my $2,000 client, that I'm working on getting I'm hoping to get some payment occur here in the next couple of days. It's add a $50 administrative fee to all of your new clients, your new contracts. Just $50. That'll cover your pre-lien. It'll cover you securing the lien right in most cases, in most states. And it will also just get you on a first. But don't close a door that you might have that might be the most affordable option for you. And guess what? Most of these are going to be dealt in arbitration. Most of these are going to be mediated. Because guess what? Most contracts, I think AI contracts, include or have arbitration mediation clauses within them, which would kind of lead me, Megan. I'm sorry, Josh. I'm going to go ahead and jump this, and I know you got. What clauses should you be looking for in your contract to ensure that you leave as many doors open as possible?
Yeah, something I wanted to say was with the lien stuff, like say it's $50,000 out there. I mean, when you think about they're gonna pay somebody even 10 grand, you know, 40,000 of that, typically 45 even, is going to vendors. So you're really gonna pay 5 grand just to pay other vendors. So yeah, you really, really have to think about, like, do I want to put 50 grand down for 50 grand when I'm basically going to be paying 50 grand or 45 grand out of my own pocket to do this because the rest of it has to go somewhere else? Or do I just let it go and just say, you know what, that was my 6-figure or my 5-figure learning method this time, and I'll learn from it. We have to actually do something with it.
And if you're a subcontractor that has proactive processes to protect payment, encourage your lower tier subs and suppliers to do it also. Because then if you're not getting paid, then they're not coming after you directly for breach. They can then go after the people that are actually not paying them. Because guess what? If you're a first tier subcontractor with a second tier subcontractor that is not getting paid and all they have to rely on is breach, they're going to go after breach, which means they're going after you, even though you haven't gotten paid. Yeah. So those are the things, you know, and flow down clauses are only going to last in certain states. But to the pay when paid, pay if paid. If you have good practices, ensure that who you work with has good practices, because it absolves you in the event that you are not getting paid also.
And like we said earlier, like when those people come after you for breach of contract, it's your house on the line for the owner not paying the GC, not paying you. How messed up is that? How messed up is our country that is like the standard practice right now? Seriously.
The risk is real.
Well, like, imagine going to Burger King and they're like, no, we're going to sue the burger guy because he cooked this thing, didn't do it right, and we're going to take his house and his car and everything else. Like, who cares if he's homeless? It's his fault, not the whole structure. That's messed up.
Well, but that's why when you look at statutes and when you look at what the state that you're working in requires, that's why if everybody, it's not, but at the same time, Josh, to what you just said, it's not Brian's job to cover my ass. It's my job to cover my ass.
Exactly.
If I'm a second tier sub on a project and Brian's like, I'm going to do a pre-lien. If Brian is doing pre-liens, he shouldn't have a problem with anybody below him doing pre-liens. Because guess what? Guess what a pre-lien does? It doesn't hurt anybody but the property owner. Whoever owns the dirt or whoever is holding the bond. That's who it's hurting. So when if Brian were the first tier sub and I'm the second tier and I'm like, Brian, I'm going to go ahead and pre-lien this. Oh, no, don't do that. I did it for all of us. Bro, no, you didn't. You did it for you. You did it for you because it's my responsibility to cover for it. You know, I think expecting someone else to protect me for me, that's half, you know, that's wrong in business. You should never think that.
That's silly to not spend $35, $50, whatever. And back to that point, like, we actually, when we work with people, we get them to put in at a minimum $600 per contract. And if you are going to lose a contract over $600 because you think raising your price, you're not going to win it, like, go out of business now, because you're not even a for-profit business. If you think that you're gonna break the bank, or do better work, you're gonna get work no matter what. You might as well do it right.
I have a client who was the Red Line King. Megan would have loved him. And he was known in Arizona. He was known in the Valley for being the Red Line King. But guess what? He only had to do that at the beginning of his career for about a year, and everyone who contracted with him afterwards knew what they were getting in with. They'd get great quality, they'd hit timelines, they'd never screw you over, He was going to redline pay when paid, pay is paid. He was going to adjust retainage to be able to meet lien timeframes, and he would not agree to flow down clauses and in when it came to indemnity, and then when it came to liability that wasn't his. This dude knew what he was doing, and he was ruthless about it. And he said, "I don't care. My company is more important than their comfort level."
Well, and to Josh's point about the house and the bank, so when you leverage your house with the bank, what do? They ask for all sorts of collateral and leverage on you. And if you're going to use that money in a project, you have to do the same thing. You have to have leverage and those processes in place. The bankers, even if you know the banker and you're great friends and you go golfing every Tuesday, he's still going to say, you know what, I'll give you the loan, but you're going to need to put up collateral. It's the same thing when you are financing your projects. You have to have collateral and process to get it back,
We have a client,
even if you're a friend.
We have a client that's the largest GC in the region for one of our smaller local banks. Hands down, one of the largest. And guess what? He is having a mother of a time getting his funding approved by that same bank for his corporate office.
Correct.
Yeah, I think the last thing I wanted to kind of end on was going to be just lien rights. And so, Megan, I'm going to throw this to you first. I'm going to give it to Amy and Peter after that, and then Bryant, I'll let you kind of chime in too. But if a contractor has never done a preliminary notice or a lien or anything like that in their life, what's the first step they should do on Monday or after watching this?
I know you are a big fan and advocate of AI tools, Josh, so you're going to like my answer. Go to your preferred free AI tool, Gemini, Chat, Claude, whatever your preferred free tool is. Which one?
Claude.
Claudia. Whichever your preferred free tool is. And tell it what state you are in. Tell it where you are in the line of what we call contractual privity. That just means who you have actually entered into a contract with. So whether you're the owner, the CM, the GC, the sub-tier or the subcontractor, or a sub-tier subcontractor, or even a material supplier, tell them who you are, what state you're operating in, and ask it to teach you, like you are a fifth grader, what the process is for liens in your state. Then that's step one. Read it, understand it. If you still don't understand it, have it dumb it down for you even more. And I don't say that, I'm not criticizing you if you don't understand it, because lawyers write this stuff and even I have trouble understanding it. So like, it's written to be not understood by the average person, because I guess we all thought as lawyers that was going to keep us in business. So don't feel bad if even at the fifth grade level you still don't understand it. Have it explained to you at the first grade level. There's no shame in that, just so that you actually understand and internalize it. Get to that point, and then hire Amy and Peter to actually do it for you, so that you know you're not screwing it up. But that's still the second step, because I still want you to actually understand the process yourself. Because if for some reason you hire somebody that's not Peter and Amy, because I can personally vouch for them, because like I said, I've sent clients to them, so I know they know their shit. I don't know Joe Blow who does liens. They may not know their shit. So I want you to know, so you can.
Or they might not care. Like
yeah, they may not care, right? Like I don't know the other people. I can vouch for Peter and Amy because I've worked with them and I've had clients that have worked with them. I don't know anybody else. But even with Peter and Amy, even if you hire Peter and Amy, I'm sure that they would not disagree with this advice, which is you should understand it yourself too. Still have them do it to make sure it's done right, but you still need to understand the process. You still need to understand what your rights are, what the timelines are, what the process is, what your remedies are, and overall understand the lien rights within your state that you are operating, and then hire somebody better to do it.
Exactly. And if you're going to vet lien companies, the one thing you should always ask for is a copy of their E&O insurance, their errors and omission insurance. So it's because guess what? Everyone's human. And if there is a mistake by your lien company, you have remedies through their errors and omission insurance, because we will be the first people to hand that out to everybody. And we carry $2 million clauses on each of our companies, just to make sure that our clients are not the ones damaged for our mistake, whatever that might be, if there ever is one. It's just
human. But you know, AI. Now we have AI.
We're mostly human. With tattoos on our faces.
Sorry, I didn't mean to interrupt you. Go ahead.
No. It's part of the vetting process. Like with Megan and attorneys, make sure you're working with someone who knows their stuff. They have to be doing this. They have to be engaged. If it's someone that's out on social, in California, when I blessedly don't have a lot of issues in California right now because the liens are so specific, they're so direct. But if you are going to be working in California, get someone like Megan. Call Megan up if you're in California. Hell, the contract pieces, that's national. It's national. engage with an attorney, engage with Megan, engage with her to say, okay, sit down with me. What's it going to cost me to have you on a Zoom with my entire team to look at the killer contract clauses? What's going to kill my project? What is my risk? What is my vulnerability?
Yeah.
Assess risk on day 0, not day 1.
Yeah.
Before you, and estimating, hell, know before you even want to bid the job whether you want to bid the job. We talked about major corporations. You think, oh man, there's no way I'm gonna have a payment problem on that. Oh hell yeah, you are.
Let's just
Yeah.
say companies that rhyme with burner do this to some small subs every day. And just because they've been in business and they're $1 billion company doesn't mean that they have their crap figured out. They're just going to bully you, and they can because they have money.
One
to
could
do.
argue that the big ones are the worst offenders because they know they can get away with it. I'm just saying.
Yeah.
Absolutely.
Oh,
You're absolutely
I
right.
mean, I've worked for $1 billion electrical company that got bullied by one of those, and like, it's whoever has the most money who can win, who can attrition.
Outspend on legal.
Yeah.
Yeah.
And Megan.
And I would advise everyone who's listening to this to reach out to Megan and set up some sort of training and set up some sort of education to say, what should I really be looking at? We're using AI contracts, or we're not using AI contracts. We're using back of the napkin. Look, ChatGPT and all the AIs can be good for some things. You still need to run that by your legal counsel to say, am I going to be in trouble with this? Because
Brian,
guess
we're
what?
being
They are
called
not
out.
attorneys. What?
Brian and I are being called out. We did that.
Well, you
We
did
had
that
to
at
do it.
first, and then you called me. So
Well,
let's.
But then we went to you, right?
We wanted to
knew
give
what
you
we were
a good starting point of what we've already discussed.
Mhm.
And we did that,
is
and we
sometimes-
erased the whole thing.
Well, it's sometimes easier for your attorney to review work you've done rather than ask your attorney to draft the work. And candidly, I don't think Megan wants to sit there and draft up a freaking contract,
Well,
but
she
she'd
did.
like to review it and say, no, and redline, nope, absolutely not. Have you even looked at the statute in that state? What are you trying to do here?
Right.
It makes sense because we'll have clients ask us, well, we can't do that. I can't look at I would love to. Doesn't mean I don't understand it. I'm looking at you in the eyeballs and I'm saying, please contact your attorney. That means there's probably something in there that's going to get you in trouble.
Or you could just come to Converge and meet everybody and get it all done.
I just
together.
know
Yeah,
people.
good
Yeah.
one
So
there.
Megan,
Yay!
I want to throw this out there for you, Megan, because you do coaching and you've gone to, you're in California, but you've gone to Miami recently. I'm sure you've gone to Dallas and done it.
Yeah.
I've seen, I can't remember all the places off the top of my head because I talked to too many people, but you've gone all over the country and you do them virtual too. So like, why don't you throw out just like a couple random prices if you feel comfortable to do that, because it's well worth it.
Yeah, I mean, it definitely pays for itself tenfold, right? And I will just say I've never given a proposal that that was rejected based on price. But the price depends on a lot of factors, so it's a little bit hard for me to give numbers. I'll give you if somebody listening or watching decides to reach out to me, I'll give you numbers. I'm not being opaque by design. It's just it depends on a lot of
Depends on the
factors. Whether you
size,
want it to be
the location.
in person, whether you want it to be virtual, how many people you want to be involved in your team, whether you want me to record it and give you lifetime access to the recording so that you can use it with future PMs as you bring in new project managers. Right, like there are all sorts of factors. Also, what kind of training you want me to do. So I've got my standard out of the box 8 key contractual provisions training that talks about what I've decided based off of my years of practice, what are the 8 most significant contractual provisions in terms of profitability and risk management on a project. And so we can go through that. Or I also offer a training, obviously it's more expensive, but I'll take your actual contract and I'll teach your team how to properly manage it, again, to produce profit, to increase profitability and manage risk better. So I've got some customized versions available that cost more, but I've also got some pre-made versions that are more accessible and more affordable. I'll do it in a one-on-one format, or I can do it in a team training. So I'm not being intentionally vague. I mean, so that it doesn't sound like I'm trying to avoid the question. I think my lowest cost offer is $2,400, and again, it totally pays for itself.
And if you do $1 million, I'm just going to put that in perspective. That's like less than 0.1%. So really not a big deal, right? Like if you go ahead.
And I will say, if you're a client of either of our companies, and we're going to be posting it internally, a link to contact Megan directly to do a contract review, to at least look at what these trainings might be for their teams, and to just get some education, because my God, what we see on a daily basis. I mean, it's not. Look, I understand everybody has the best intention. Everybody has the best intention when they go onto a job. Nobody walks onto the job site thinking, I'm about to screw everybody. Well, maybe a couple of owners, and I won't name this apartment complex chain by name, but they will 100% hire people just to screw them. And there are GCs that they call them subbusters, right? You know, there's plenty of GCs that are subbusters. People know who they are. Everybody here knows who they are. But at the end of the day, nobody gets onto the job thinking, man, I just can't wait for this to be the worst, crappiest, sideways job I've ever worked on.
Right.
Nobody.
Yeah.
It happens, and it happens way beyond your pay grade.
The stats are 90% of construction companies aren't going to make the long haul, and 90% of the reason has nothing to do with the job site. So,
That's a great stat.
Yeah, it's like
Who are you?
96% of construction companies fail within 10 years. So
yes.
that's Bureau of Labor statistics. It's insane. And like you said, it's just one project. I mean, you can do 100 projects, but like we said, one goes to litigation, one loses all the progress you've ever made in your house and your boat and your kids' college fund and everything. I've seen it, and it's sad.
Yeah,
But,
we've seen it. Again, it's heartbreaking. Nobody wants to do that, and we take it personally. What I think one of the benefits with us, because we do have the two companies, is that if our clients are about to lean each other, it'll be a phone call, it'll be an email, it'll be like, don't make it awkward at the holidays. Could you just please pay them, so that we don't have to lean clients. We don't like leaning clients, but when one of our clients who's a GC says they need to lean it, well, then we know what the real problem is.
Mm-hmm. Yeah.
That means it's not them.
But typically, the people that are your clients are also the good GCs. I doubt there's any bad ones that you guys work with.
No. We do not work with any.
If you find out they are, then you don't have them anymore.
It's actually true. We only work with contractors that we would stand by and say and be proud of, honestly. And we've got some that we're really proud of. So, and we work hard to maintain those relationships. But that's, But at the end of the day, at the end of the day, work. Bless you. My goodness, it's allergy season in California.
Well, let's wrap this up. Brian, is there anything you want to add? I mean, I feel like we just left you alone.
No, I'm good.
At least
Love
you
you,
moved from
Brian.
yeah.
No, that's you guys covered the ground. I learned, so that's what I came here for.
We invited Brian so he could learn. That's about it. No, I'm just kidding.
So I assume that you also get like a lot more views because my face is on.
It's 100%. I mean, even Caleb had a comment about you. I can pull it up.
Yeah.
He said,
Please pull that up before we disconnect.
I can't share it, but I can read it. It says, Brian Solomon's smolder is looking good today.
Oh.
I don't even know what that means.
So these aren't mean tweets now. Now we have nice tweets.
I don't have any mean tweets for today, unless you want me to put the one you gave me for Megan and me. That's
yeah, you gotta put the one for Megan that I put up there.
Oh boy, I'm sorry, Megan.
She hasn't been indoctrinated into the mean tweet club
You
yet.
have to read it, Megan.
Okay. I have to read it myself. Okay, where do I look?
Yep.
All right, Megan, I'm going to put it up here for you. Oops, not that one.
I was like, oh, that's easy. Hashtag not legal advice.
Okay, are you ready?
Yeah, I'm ready. Every time Megan Shapiro says fuck, a demon gets its horns. That is excellent.
Which is also a lot of times.
I think because I dropped it a few times this live stream.
And
I know
reconstruct-
it was perfect. It was right
Brian
after
wrote
I
one
said
other
that.
one, and I don't want Megan, our guest, to be the only one that has to do this, so I'm going to read the one he wrote for me. And it's totally true, I guess. ChatGPT. Josh wants the front row seats to Taylor Swift concert for just himself. And I needed 2 seats because I had to bring my bag full of stuff I wanted to get signed afterwards.
That's exact. I was like, you need to
You
get
had
the
your paraphernalia.
So Megan, you're not alone. I had to do the mean tweets. Next time, I'll let you write them for these two.
I can't
Okay,
think
fair
of.
enough.
I couldn't think of one on the fly for you and for Peter
That
and
was
Amy. I'll
awesome.
get one next time.
Probably
I
something
got a good
about
one
face
for
tat.
Caleb, but Caleb's never coming back after he heard
I'm
about
gonna
this
make
one.
my mean tweet into like a testimonial and add it to my website.
You want to read it one more time? I'll make you the primary one, so it's a really nice looking one.
Sure, let's do it.
Okay, here you go.
Okay.
Let me wait. I want this, and then I have to recopy and paste it. I'm sorry, I copied over yours.
Everybody that's live right now is like, do we have to be on still for this?
Yeah, you have to stay. This is homework.
Yeah.
All right, here you go.
Okay. Every time Megan Shapiro says fuck, a demon gets its horns.
Well done.
All right. Well, with that, let's all get out of here and enjoy the rest of our day.
Thanks, everybody.
Thank you
Thanks,
so much
everybody.
for having me
Great.
on. See you guys in Chicago.
Yeah.
Yeah, I
yeah.
can't wait.
See you, Megan.
We'll see